Proposition 57, could we get the next analysts up? While they're coming up here, I did want to make a clarification that came up 2 years ago when we had this event, which is when you look at your ballot or your voter guide, the first section is the LAO analysis, these people. And they do the fiscal analysis, they're nonpartisan, they're trying to come up with the best possible factual situation. The arguments in favor and the arguments against are by proponents and opponents, and they are not vetted for accuracy necessarily. So it's possible that there's something that could be exaggerated or misleading in those parts. So just be, caveat emptor on that. All right, so we have Drew Soderberg on Prop 57.
Hi, so Prop 57 really has two pieces, one that deals with the adult criminal justice system and one that deals with the juvenile system. So I'll start with the adult piece first. Individuals who are in prison have been convicted of a primary offense that they're serving time for. However, some individuals are also serving time for other offenses they were convicted of at the same time, or time associated with sentencing enhancements that have been applied to their term. However, sentencing credits, which are awarded based on good behavior or participation in education or rehabilitation programs, can reduce the amount of time that offenders serve in prison, though state law does limit the amount of credits that individuals can earn to reduce their sentences. Proposition 57 would change the adult system first by specifying that nonviolent felony offenders would be eligible for parole consideration once they've served their primary term. That means the Board of Parole Hearings would decide whether they're released before they serve any additional time associated with sentencing enhancements or with other crimes that they've also been convicted of. It also changes the state constitution to give the state prison system the authority to award credits beyond the limits that are currently specified in statute to inmates, which could further reduce the amount of time that inmates serve. Now I'll turn to the juvenile portion of the measure. Under current law, youth who are accused of committing crimes before they are age 18 are usually tried in the juvenile court system. However, in certain circumstances, they can be tried as an adult. This generally happens in three different ways. First, if the crimes that they're accused of or their criminal history is serious enough, they could be tried in juvenile court, in adult court on a mandatory basis or at the discretion of a prosecutor. However, in some cases, in less serious circumstances, youth can only be tried in adult court at the discretion of a juvenile court judge. Prop 57 would change this so that youth could only be tried in adult court at the discretion of a juvenile court judge. So now I'll talk a bit about the fiscal effects of the measure. It really has two major fiscal effects. First, we estimate that it could create tens of millions in dollars in savings from a reduction in the prison population. This is largely related to the parole consideration and sentencing credit provisions of the measure. However, the precise savings would really depend on how the measure is implemented, whether the parole board chooses to release inmates, and how many additional credits are authorized by the prison system. The other fiscal effect is that it could increase county costs by a few $million annually. This is really related to the juvenile portion of the measure, because counties experience increased costs when youth are tried in juvenile court rather than adult court.
Great, so support, we have the California Democratic Party, Libertarian Party, Peace and Freedom Party, Democratic clubs, and in opposition, the Republican Party. In support, we have the California Faculty Association, which is state university faculty, California Federation of Teachers, law enforcement, Catholic bishops, League of Women Voters, so a whole series of organizations. And then in opposition, we have sheriffs, attorneys, homeowners, peace officers, mostly police in opposition. And then in support, we have Governor Brown and Lieutenant Governor Newsom, and a number of other former Speaker Newt Gingrich, for some reason, is weighing in on California politics on this one. And why not? He weighs in on everything, right? And then in opposition, we have 31 Republican officials, 1 Democratic, 19 police chiefs, sheriffs, and district attorneys. And then newspapers are split. And the spending is very lopsided on this one, $8 million in favor and only $121,000 against. The in favor largely comes from the governor's committee. He saved a lot of money and not really fighting for his reelection. And the California Democratic Party, Reed Hastings, who's the Netflix bazillionaire. And then in opposition, we have district attorneys and a casino, peace officers, but there's not a whole lot of money in opposition. Questions?
What are some examples of nonviolent felonies?
So one thing that we noted is that the measure doesn't define nonviolent felony. Instead, state statute currently has a list of violent felonies. And so for the purposes of our analysis, we assumed that anything that's not on that list would be considered nonviolent. So the list is relatively extensive, both in terms of crimes that wouldn't be on that list and crimes that are on that list.
Where is that list posted?
That list is in a section of the Penal Code. It's section 667.5B, maybe? I don't know how helpful that is for you. But if you were to look it up on the internet, you'd probably be able to find the list. That resource is generally available.
This doesn't take into account plea bargaining or crime down, does it?
So plea bargaining and pleading down to lesser crimes occurs before the conviction. So the Proposition 57 would kick into effect only after someone's been convicted. So in other words, they could be accused of a more serious crime, plead down to a lesser crime, and then Prop 57 would say, once they've served their primary term for that lesser crime, then they'd be eligible for parole consideration.
So it could be a violent offender that just plea bargains something down.
It's possible that somebody could plead out of that.
And one last question in the middle.
Does this apply for the mental health as well?
It doesn't specify mental health status, so it would apply to mentally ill offenders as well, though presumably someone's mental health status would be considered by the parole board if it was the parole consideration, and also by the juvenile court judge in deciding whether to assign them to adult court.
Thank you.